Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law Section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Welcome to our Curious Amalgam. I'm Alicia Downey, and the title of today's episode is What Happened in 2022? What will happen in 2023? Looking back and looking forward with the sector committees. This is the first part of a two-part special year-end episode. If you're a member of the Antitrust Law Section, you have the opportunity to engage with a huge variety of substantive committees that produce publications and programs about cutting-edge developments in antitrust, competition, consumer protection, and data privacy law around the world. In this year-end special, celebrating the end of 2022, our guests are all leaders representing 6 committees focused on the most important industry sectors in our economy. We'll be hearing from Health Care and Pharmaceuticals, Agriculture and Food, Distribution and Franchising, Transportation and Energy, Insurance and Financial Services, and the Media and Technology Committee. We'll be looking back at the most important developments in 2022 and looking forward to predictions about what 2023 might bring. My co-hosts are Sergei Zaslavsky and Jaclyn Phillips. Sergei, who are we talking to first?
So we're very lucky to be able to welcome Lauren Rackow to the program. Lauren is the co-chair of the Health Care and Pharmaceutical Committee. Welcome, Lauren.
Thank you so much. It's wonderful to be here.
Great. Why don't you tell us what are the most important antitrust developments from 2022 in the healthcare and pharma space?
There is one particular transaction that I wanted to highlight, and that is United Health's acquisition of Change Healthcare. That went to court. It was a challenge by the Department of Justice. The transaction decision came out in September of this year, and the transaction also closed shortly thereafter. What is particularly interesting about this matter is that the Department of Justice has in the past said that they're going to be challenging more cases versus, solving them with divestitures or other conditions. And this was an example of that, and that they're also going to be trying novel theories. So to give a little bit of a background on that case, United Health is a vertically integrated healthcare company that has 2 main branches. United Health, which provides commercial health insurance, and also Optum, which has 3 different subsidiaries. The main one of interest here is Optum Insight, which offers software solutions and services for healthcare business needs. Change Healthcare is a healthcare technology company that provides data solutions aimed at improving clinical decision-making and simplifying payment processes across the healthcare system. This transaction is primarily a vertical integration, but as well there was one horizontal overlap where United Health had negotiated for the divestiture of a certain part of its business in order to present a transaction that wouldn't have as many anti-competitive issues. So the DOJ alleged that the transaction would incentivize United Health to boost United Healthcare, which is the country's largest insurer, by abusing Change's access to rival insurer competitively sensitive information. They also proposed that the transaction would reduce innovation, and also in terms of the horizontal overlap, which was between Optum Insight and Change's Claims X10 claims editing unit, that merger would lead to a monopoly. So after a trial, what the court ultimately found was that United Health would not be incentivized to misuse rival health insurers' data. United Health already had access to rivals' data through Optum, and it had not misused this data. The court also found that United Health had firewalls and other protections to ensure that the data would not be abused. And there was also testimony from United Health as well as rivals that illustrated that abusing rivals' data was not supported by the evidence. The court found that the same protections would apply both pre-merger and also post-merger. The court further found that there was no evidence that the transaction would reduce innovation and stated that the evidence showed that United Health had never withheld an innovation from competitor insurance companies. Finally, United Health had an agreement for the private equity firm TPG to acquire Claims X10, and that fully resolved any issues that were raised by the horizontal overlap. So the reason I selected this as one of the premier cases to discuss from 2022 is that the DOJ put forth a couple novel arguments that the court rejected. The DOJ, for example, argued that the transaction should have been analyzed without the proposed divestiture. The court indicated that the DOJ seemed to argue that United Health and Change must prove that the divestiture will maintain the same level of competition that existed in the pre-merger market, whereas the text of Section 7 is concerned only with mergers that substantially lessen competition. By requiring that United Health prove that the divestiture would preserve exactly the same level of competition that existed before the merger, the government's proposed standard would effectively erase the word substantially from Section 7. So even though the court found that the government standard was inconsistent with both Section 7 and the framework that's been used to analyze mergers, it still did use this higher threshold in its decision. The next interesting thing was that the DOJ also seemed to reject that a private equity firm, here TPG, as a divestiture buyer, would be able to run the business as well as United Health or Change would have been able to run it. The court rejected this. They found that the evidence showed that the private equity firm would be able to, and if anything, would have been able to devote more resources to the divested business than Change was prior to the transaction. So the transaction closed in October, and we recently learned that the DOJ will be appealing this case. So we could look forward to seeing what will be the outcome in 2023.
That's very interesting, Lauren. Actually, one of several big merger decisions that came down in the second half of 2022. And actually, for listeners who are interested in learning more about this case, I suggest you search United Healthcare on our Curious Amalgam podcast, because we have an entire episode devoted to this case, as well as the Illumina Grail merger. So, Lauren, obviously, one thing we have to look forward to in 2023 is the appeal. Is there anything else you wanted to highlight as things to look forward to in 2023 in the healthcare and pharma space?
Yes, absolutely. So we certainly seen in terms of healthcare provider consolidation, more consolidation in the past 5 years. And we expect that these combinations will continue to receive significant scrutiny and that they will continue to be the subject of investigations and enforcement litigation. We anticipate that doctors, hospitals, and other providers will continue to integrate and that coordinated healthcare and these relationships will continue to draw scrutiny. Turning to health insurance and ancillary business integration, what we've seen and what we expect to continue to see is that following the failed merger attempts from the largest national insurance carriers in 2017, we have seen the large health insurance companies branching out into ancillary businesses beyond their traditional insurance roles, including into the provider space and healthcare technology space. I think the United Health transaction we just discussed fits into this category as well. We're also expecting to see pharmacy benefit managers under the spotlight as a possible cause for higher drug prices. The FTC is currently conducting a 6B study on PBMs and otherwise scrutinizing their conduct and transactions. And we think that we will get the results of the study next year, and it will be interesting to see how that continues to develop. Turning to the last category that I was going to discuss, which is pharmaceuticals, we think that we will continue to see pricing issues in this area. We have seen both the U.S. enforcers and also across the pond, the European enforcers, investigate collusion and price spikes in the pharmaceutical industry. This will continue to be an area to watch as these cases proceed through investigations and litigation. We're also expecting, in terms of conduct cases, to see more activity in that area. We think that we will continue to see reverse payment cases and that we will also see action in terms of other anti-competitive practices that are aimed at preserving a dominant industry position on the part of the pharmaceutical companies. These practices can include denying generic developers access to samples of branded drugs, utilizing REMS programs to create barriers to generic entry, and product extensions that thwart generic entry. We anticipate that enforcers in both the U.S. and again across the pond will be increasingly focused on overlaps in pipeline products and development strategies among merging parties. We're also seeing that enforcers are concerned with an established company acquiring a nascent competitor, and that acquisition of cutting-edge pharmaceuticals, devices, and technology may receive intense scrutiny. And we anticipate that the scrutiny of pharmaceutical mergers will broaden to include a variety of effects and transactions in which the parties' products are not likely to be viewed by physicians as direct substitutes, such as concerns about innovation effects, cross-market effects in payer contracting, and changes in incentives to compete. So I think really there's a lot to look forward to in 2023.
Yeah, sounds like it. A lot of good stuff. There's something for fans of Section 7, fans of Section 1, Section 2, a lot of novel theories. Definitely a lot to keep our eyes on. Well, thank you so much for joining us, Lauren.
Thank you. It's been great to be here.
Jaclyn, would you like to introduce our next guest?
Absolutely. We're here with Brian Rathkin. Brian is the co-chair of the ABA's Agriculture and Food Committee. Welcome to the show, Brian.
Thank you. Appreciate it.
So we're looking back now at the ag and food industry during 2022. What would you highlight as one of the most interesting or important issues of the year?
I think the biggest development in the ag and food space in 2022 was the DOJ's $85 million wage fixing settlement that it brought against 3 of the largest poultry producers in the U.S., as well as a data consulting firm. And so what makes this case particularly interesting is not just the fact that it bears on one of the most important industries in the United States, which is poultry processing. American consumers certainly eat a lot of chicken, but it's also showing the DOJ's as well as the FTC's renewed focus on employee issues. So in terms of wages and employer monopsony, which we all know in the antitrust world has been getting a lot of airplay in the last year or two. So to give you some background into this case, back in July of 2022, 3 chicken processors, which are Cargill, Sanderson Farms, and Wayne Farms, agreed to pay a combined $84.8 million to settle allegations that they were suppressing poultry plant workers' wages by secretly sharing wage and benefit information, and that would be in violation of Section 1 of the Sherman Act. According to the DOJ's complaint, the poultry processors engaged in a long-running 20-year conspiracy to share confidential employee and wage benefit information, and then they collaborated on decisions about those employees' current as well as their future compensation. And the poultry processors also hired a data consulting firm which facilitated this information exchange. So specifically, DOJ alleged that the defendants, as well as unnamed other poultry processor conspirators, were sharing current and future disaggregated and identifiable wage information, which allowed the employers to collaborate on employee salaries and bonuses, as well as also future planned wage increases. The companies exchanged this information both in person as well as electronically via email and phone, with the complaint explaining that the parties even went so far as to meet annually, and each company would bring printouts of their disaggregated employee wage information, which they would then share at these meetings. Notably, I think an interesting feature here is that the parties hired a third party called WMS to manage the information exchange. This is something that we as antitrust lawyers typically recommend to clients. We recommend that parties hire a third party in order to facilitate an information exchange, to aggregate information that parties provide to them, and then spit out a aggregated version of this information that complies with the appropriate antitrust laws. But here, the third party actually operated as a facilitator of the conspiracy. So there's I think there's a number of different takeaways from this case, but the one I wanted to talk about here fits my interest, which is as a merger lawyer primarily. So I'm really interested in looking at this case and thinking about how this case is going to bear on future government agency merger investigations or challenges, and see how in particular, how the government defined the relevant market and applying that to the merger world. So just as in typical good and services markets, what the DOJ did here is define a test for defining a labor market based on substitution. In other words, could a single employer, a monopolist of all poultry processing jobs, profitably lower wages or benefits by a small but significant amount? So DOJ approached this in kind of three different ways. First of all, it looked at the worker's perspective. So who would workers view as alternatives to their current poultry processing job? And DOJ alleged, of course, that other poultry processors would be their closest substitutes in terms of working conditions, in terms of the tasks and skills employed. Second, the DOJ also took the converse route, where it looked at the poultry processors and said, well, who are poultry processors looking at in terms of their employee pool? And DOJ basically explained that poultry processors are looking for poultry employees, right? They're likely to hire their employees from competitors. And third, DOJ also employed a tactic that's frequently used, which is clustering. DOJ combined a number of different poultry processing jobs into sort of a poultry processor employee market, which is comprised of multiple different jobs. And this was kind of made easier for them because the parties were bringing together sort of standardized jobs. Each company had standardized jobs that were similar across the companies. But I think if you're thinking about approaching this from a litigation or investigation, testing the substitution in labor is more complicated than when you're talking about a normal good or service market. It's complicated by factors like location, people's families and friends, macroeconomic conditions, company or industry specific conditions, as well as, of course, the fact that people don't switch jobs as frequently as they buy products and services. So let's just kind of think about if DOJ were involved in a litigated merger challenge and this weren't a settlement here. On the product market side, could DOJ show that employees don't have sufficient alternatives? So could a live hanger, a person who hangs chickens in a poultry processing plant, or a butcher really not move to a beef or pork processing plant? Could they not move to a grocery store or a local butcher shop where they might be performing a similar task to their current job? What about even other manufacturing jobs in the areas or other jobs altogether? Are those reasonable alternatives for these folks? And frankly, as a layman, it's not immediately obvious to me why a poultry plant worker can't go work in another plant, such as a beef or pork processing plant. Now, there's probably some different job requirements and some retraining that they would need to engage in. But at the end of the day, I could see folks working in a poultry processing plant taking a job in a beef or pork plant if they felt like it was a better fit for them. For example, it had higher wages or was better working conditions or something. Now, the types of jobs at issue also will be a relevant factor in looking at these labor cases. Theoretically, a merger could harm employees of any stripe, be it executives all the way down to the lowest level employees. But I think practically speaking, the agencies are going to focus mostly on these mid-level employees where they're relatively low paid, but they also have some skills. And the poultry processor example fits right in here. It implicated lower paid but skilled processing plant employees, such as the live hangers I mentioned, butchers, plant mechanics, but it didn't implicate the highly paid plant managers or executives, and it also didn't implicate the low-skilled workers. There's also, of course, that was product market, but there's also geographic market issues that a government challenge would face here. Labor, of course, is mobile. People are willing to drive reasonably long distances to get to work, and people also are willing to move in order to make more money or change their job. So will the agencies be able to prove up a geographic market that's small enough to define a market where there are high shares among the employers.
Thanks, Brian. This is all incredibly interesting, and you sort of brought together, an industry that we're all hearing a lot about and watching with interest, with a lot of, themes that I think we can all look to over the next year as well, which brings me into my next question for you. So what trend or cases specifically related to ag and food does the committee predict we'll see, in the news when the calendar hits 2023?
So maybe part of this is a hope, but this is following on to my last discussion about the poultry processor case, is that I think in 2023, we'll see the agencies bring a true labor monopsony case. Now, what we've seen over the last couple of years from the government is things like wage fixing or no poach, where you've got employers who are agreeing not to hire each other's employees. But I think in 2023, I'd expect to see a more kind of true labor monopsony case where the government is alleging that an employer is going to have market power over employees and can either reduce their wages or hold them steady. And that would be in the context of either a monopolization Section 2 case or a Section 7 merger challenge. My guess is that any government challenge here will focus on these kind of mid-level workers where you've got relatively low-paid positions, but skilled workers. I don't expect that we'll see challenges to occur at the higher level for executives where they have a lot more ability to move within both the same industry as well as changing industries and geographies altogether. And on the lower end, frankly, people just aren't skilled enough to make it worth their while. So I think we're going to focus on this middle ground. Personally, I would love to see a litigated case, because then we could really get some insight into how both the government and the merging parties will approach their arguments. And in particular, I'd be really interested to see the economic work on this. We haven't really seen that to date. Seeing economists bring to bear, internal company evidence about where they're hiring people from or where workers are going to when they leave their positions. We might even see like mining of LinkedIn data or Glassdoor data. I think it could be really interesting and novel to see what people do.
Yeah, absolutely. And I think in 2023, we'll all be looking out for a lot of clarity and just how some of these new themes and focus of the agencies will pan out. So that is a very enlightening prediction. And I guess we'll be watching with interest. So Brian, thank you so much. And we hope you have a great new year.
Thanks for having me. You too.
We've got time to talk to one more committee. Next up is the Distribution and Franchise Committee. And with me are Adam Goodman and G. Lehman. Welcome to our Curious Amalgam, Adam and G.
It's great to be here.
Yeah, thanks so much.
What's the one development in 2022 that your committee thinks was the most significant?
So thanks for the question. There are actually several antitrust developments in 2022 that were particularly noteworthy in the world of distribution and franchising, and those included the adoption by the European Commission of a new vertical block exemption regulation, or VBER. Also in the summer, the FTC noted in a policy statement that it might consider using the Robinson-Patman Act, which concerns price discrimination in certain circumstances. But likely, and this probably puts us as kindred spirits with the Agricultural and Food Committee, the most newsworthy development this year has been the jury verdicts in the two criminal trials, which ended up dismissing charges laid by the DOJ concerning wage fixing and no poach agreements. So again, in the labor market, these trials in the Jindal case out of Texas and the DeVita case out of Colorado were the first litigated resolutions that followed the DOJ's and FTC's 2016 policy, which said that they would pursue these types of agreements between employers on a criminal basis, whereas previously, and going back to a 2010 case, they had pursued that type of conduct civilly. The Jindal case concerned an alleged agreement to lower the rates of that physical therapists and physical therapist assistants were paid in Northwest Texas. The case appeared as, to antitrust practitioners on paper to be potentially quite strong, given that the DOJ had text messages between the accused and other employers sharing wage information, etc. There were even texts saying, "Yes, I agree." However, the cooperating witness had previously stated she didn't think that this quote-unquote agreement was serious, and wages were never actually adjusted to conform with the alleged scheme. The accused ended up being convicted on obstruction charges, but not the antitrust charges regarding wage fixing. And if anything, the Jindal outcome suggests that proving the existence of the alleged agreement, which has long been the material speed bump to obtaining a conviction on traditional price fixing cases, also applies in these types of labor cases. G, you were personally involved in the DaVita case. Could you tell us about it?
Sure, of course I am. Happy to. So the DaVita case involved allegations that DaVita, which is a leading provider of kidney dialysis services in the U.S., entered into agreements with 3 other healthcare companies not to solicit each other's senior level employees unless the employee notified their supervisor that they were looking for a job outside their current company. And so after a 3-week trial in a Colorado federal court in April of this year, the jury acquitted DaVita and Kent Thury, who was its former CEO, of all charges. The DOJ brought criminal charges against DaVita and Thury and argued that these non-solicit agreements were essentially the same as market allocation agreements in the product market, except that they occurred in the labor market. So in its motion to dismiss, the defense challenged that notion that the 2 types of agreements were the same. And they argued that there was really no precedence for treating non-solicit agreements as a criminal offense. But although the Colorado federal court denied the motion to dismiss, in its pre-trial rulings and jury instructions, the court really rejected the DOJ's theory that all non-solicitation agreements were unlawful market allocation restraints. And they even stated that even no hire agreements should not be definitionally subject to per se treatment. Instead, what the court did was to adopt a more stringent requirement for the DOJ to prove a per se offense by really highlighting the need to prove the intent, and the main purpose of these agreements was to end meaningful competition. And the court also instructed the jury that the evidence of lack of harm or pro-competitive benefits might actually be relevant to determining whether these non-solicit agreements should be viewed as market allocation. And these rulings really stood in contrast to how traditional per se antitrust cases proceed, and I think highlighted the notion that a typical per se approach to no-poach cases may not be appropriate given differences that are quite salient between the labor and the product markets. And they also help define a clear strategy for the defense, focus on economic analysis, showing both lack of intent to allocate a market as well as lack of evidence of anti-competitive harm, which ultimately prevailed in trial.
Thanks very much to both of you for telling us what you thought was newsworthy in 2022. Now I'm going to ask you to look ahead. What's going to be in the news in 2023?
Good question. And to go back to one of the issues I mentioned briefly at the outset, given the rumblings that we've been hearing from commissioners, both in their prior work and in recent statements, there's been a prognostication that we may see 1 or more new price discrimination cases being brought by the FTC under Robinson-Patman. There's also prognostication that we may see new vertical merger guidelines in 2023. But in our view, no-poach and wage-fixing developments will likely continue to make significant news in the coming years, both in the United States and abroad. Although both Jindal and DaVita did not result in antitrust convictions, prior motion decisions in those cases confirmed that the per se rule could be applied in circumstances of wage fixing and no poach agreements, and there have been consent plea agreements in this area. G?
So in that vein, I think an important case to watch out for is the appeal of Deslin versus McDonald's in the Seventh Circuit, which is a case involving a clause in the McDonald's franchise agreement prohibiting its franchisees from hiring staff from another McDonald's location. So just to provide a little context, back in June 2022, an Illinois federal court granted summary judgment to McDonald's. And it found that there was essentially too much competition for employees outside the franchise system for the workers to support an antitrust case. And the same court had previously denied a class cert bid from the workers, concluding that there are likely hundreds and thousands of relevant labor markets among the class members. And in denying the class certification, the court ruled that despite the plaintiff's pursuit of a per se case, the rule of reason analysis was appropriate in the context of franchise agreements. Now, we don't have much information on the details of the specific claims in the appeal yet, but it is being watched very carefully by the agencies and the private bar. And just last month, the FTC joined the Justice Department in an amicus brief filed with the Seventh Circuit, which argued that no higher provision in franchise agreements can be horizontal in nature. And these agreements are per se unlawful unless the defendants can establish that they are reasonably necessary to achieve a pro-competitive objective for the franchise system. It also argued, citing to the U.S. Supreme Court's recent decision in the NCAA versus Alston case, that it didn't change the standards, that ruling didn't change the standards for determining whether a horizontal restraint is per se legal or subject to a quick look test. So the outcome of the appeal in the Deslin matter will have important implications for how labor market antitrust cases will in general proceed, but in particular for restraints in the context of vertical relationships, franchises, and joint ventures, and what really constitutes reasonable restraints with pro-competitive justifications.
And also just to mention other countries, we've seen enforcement noises regarding no poach and wage fixing in Asia, in Europe, where the EC has commenced investigations and conducted dawn raids. And in my own country, Canada, we recently amended our Competition Act to criminalize no poach and wage fixing agreements, and that'll come into force next summer. And we're anticipating that the Competition Bureau, which is our enforcement agency, will release guidance that'll explain its enforcement approach, which will likely treat only naked restraints on competition in the labor market under the new law outlawing wage fixing and no poach. So a lot of convergence internationally, I think we'll see in 2023.
Well, that's great. Thank you so much, Adam and G, for those predictions. And I wish both of you a very happy new year. That is all for part 1 of this special episode. Thanks again to all of our guests for taking time to speak with us and for the hard work you do all year for the section and its members. Listeners, be sure to catch part 2 for perspectives from 3 more sector committees. And on behalf of all of us and the whole team at our Curious Amalgam, our very best wishes to everyone for a peaceful and happy new year.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.